with Connor James. We're from Compliance Quarter, and we're a compliance consulting company who provide software and compliance solutions for businesses with a main focus on energy. And one of the main things we've been doing over the past 5 or 6 months is helping electricity businesses obtain retail authorisations from the AER. So today's webinar, essentially, we're going to run through a few questions. The first being the difference between a retailer authorisation and an exemption, which one you may need. What are the actual requirements to obtain a retailer authorisation and the process that you need to go through, and the question of whether you can purchase someone else's retail authorisation instead of applying directly to the AER. So we'll start with the authorisation versus exemption question. So essentially, the licensing provision in the National Energy Retail Law is Section 88, which provides that a person must not sell energy to another person for a premises unless they hold a retailer authorisation or they are an exempt seller, which essentially means if you sell energy, you need to have an authorisation or an exemption. So essentially, you can see there on the slide, there is sort of 3 main criterion to determine whether you need an authorisation. The sale of energy is your main business. The main relationship you have with your customers is that you sell them energy, and you sell energy across a number of sites, not just to the one site. So those are the sort of the main considerations. And if you satisfy those, the general rule is you need an authorisation, but it's still worth checking to see if you can come within one of the exemptions. Because although they have conditions, usually they're less onerous, and there's less regulatory requirements. So it's worth checking if you can fit within one of the exemptions. They're up on the screen now. There's 3 categories of exemptions: deemed, registrable, and individual. Essentially, a deemed exemption is when you come within criteria set out in the guidelines that sort of mean that if you satisfy the criteria in the guidelines, you don't have to register or apply for an exemption. It just applies automatically, although it's still subject to certain conditions. Sort of examples of this might be if you sell energy or you on-sell energy to fewer than 10 small customers, whether retail or residential, or if it's sort of more of a temporary sale or short term, like to a construction site or something. So a registrable exemption, you actually have to register with the AER. It's not like an approval process or anything, but it's a similar sort of criteria. Examples are if you're selling energy to one site, such a caravan park or something, or if you're sort of selling supplementary energy through a PPA. So your customers are getting their energy through your PPA, but also through the national electricity grid. The third category is the individual exemption category, and that's the one that if you don't come in the first 2 categories, it's the residual class, and you'll have to actually apply to be approved for an individual exemption with the AER. So ideally, you'd want to come within one of these exemptions if you can, to avoid having to apply for a full retail authorisation. So this next slide sort of sets out the questions you need to ask. The first one being, do you fit within any of the deemed or registrable categories, D1 to D10 or R1 to R8? They're set out in the guidelines pretty clearly. If you don't, yes. If you do, then if you do fit into those categories, then you're eligible for an exemption. Although remember, you still might have to register if it's a registrable exemption. If you don't, then you need to fit into the individual exemption category and apply for approval. And the criteria that the AER looks at when assessing an individual exemption application is set out there. If selling energy is incidental to your main business, you're selling energy as a community service, or you're selling it to a defined group of customers at one site. So if you satisfy these criteria, and it can be a fine line, whether energy is your main business, or that's sort of the criteria that's open to question. Is it incidental or is it actually your main business? Can be arguable, and that's where sort of the line blurs. But yeah, if you do satisfy that, then you'll be given an individual exemption. If not, then you'll have to apply for a full retailer authorisation. The authorisation requirements are set out in section 90 of the retail law. So there's three sort of broad criteria that applicants have to satisfy. The bottom two, financial viability, financial capacity, along with the suitable person criteria, are sort of more facts. So the things you have to show the AER that are true as a matter of fact, that you've got a financial capability and that you're a suitable person in terms of your past history and commercial dealings and stuff. So in terms of financial viability, then the AER, I guess, is concerned that you have the capacity to manage the volatility of the energy market, and you need to sort of show, various sort of proofs, whether it be bank statements or letters of support or whatever, to satisfy the AER of that criteria. Sort of where the main work comes in when applying for an authorisation is satisfying that first criteria, the organisational and technical capacity, and that takes a while to get the relevant documentation together. So along with like internal systems and policies and procedures and stuff, you also need to show that your staff and particularly your management have relevant experience and ideally industry experience, electricity, experience in the electricity retail market. So in terms of the specifics for the things you need to demonstrate organisational and technical capacity, the internal policies and procedures and stuff, this is sort of showing that you're satisfying the regulatory requirements. And so things such as risk management policies, reporting policies, breach reporting and such, and a compliance policy. And then there's sort of the other component of these internal organisational systems, and that's your the more customer-centric policies like the complaints procedures and customer hardship policies and the like. So the actual process is pretty straightforward. So once you've submitted all the information, and like I said, the majority of the information you need to submit is that sort of organisation stuff. But then there's obviously sort of more just standard things like showing your like a business plan, showing you communicating with the relevant ombudsman in your jurisdiction, that you're also applying for your AMO registration. Once you've submitted all that, and the AER will come back to you anyway and ask you for clarification of some of your information or request further information that you might have missed or they might need because of special circumstances or something. So once they've got all that information they need, then they'll put this is in accordance with the rules, they'll put your application up on their website for a 20 business day consultation period, giving the general public or any interested parties a chance to make submissions or comments on your application. After this, they make the determination and they'll issue you with the decision. Generally, they suggest it takes about 12 weeks to process an application. But from our experience, that's sort of an optimistic estimate, and it can take a bit longer than that. So as you can see, if you don't fit into one of the exemptions, it can be quite a process to actually obtain a retail authorisation. There's lots of documents you have to get together, and a lot of people realise this. And a question we often get asked is, "Can I buy someone else's authorisation, or can I buy someone else's energy business?" And buying another energy business is a viable way of obtaining a retail authorisation. But to be said, it's not any easier than actually applying for one yourself. So you can transfer an authorisation through a private agreement with another entity, but you have to know that under Section 101 of the retail law that the transfer is only by a joint application by both parties, and it has to be approved by the AER. So the transfer is still subject to AER approval. And the important thing to note there is that one of the criteria for approval is that the transferee supply the same information to the AER as they would if they were applying for a retail authorisation themselves. So essentially, all that information that I spoke about and that process that's involved in that process is required if you're looking to transfer of an authorisation from another entity. And it has to be said the AER requires sort of additional safeguards as well if this is the route you want to take. The main one being that both parties, again, the transferor and the transferee, have demonstrated that they have appropriate arrangements in place for the transfer of the customers, and that the customers will still be able to be supplied with energy throughout the process of the transfer, and this won't be compromised by the proposed transfer. So there you go. That's the sort of framework for exemptions, authorisations and transfers. And